everybody. My name is Keith Cooper. I am the secretary of the Beverly Hills Bar Association Entertainment Law Section, and I am very pleased to introduce our speaker today. His name is Sky Moore, and it's short. That's his nickname, I guess. But Sky is a partner at Greenberg Lusker LLP and is a leading authority in entertainment, corporate, and tax law. He's represented a lot of major players in Hollywood financing and authored widely used texts, including The Biz. He's recognized as a legal legend by The Hollywood Reporter and is consistently ranked among the most influential lawyers in media and entertainment. This is my kind of guy, so we welcome you to today's section meeting, and take it away, Sky.
Thank you so much. Thank you very much, Keith. And thank you all for everybody that's attending. I'm deeply honored to have anybody listen to me prattle on about AI. And there's a lot going on. So let's start with what AI can do. And I would summarize by saying AI could put on this very seminar with me as the speaker and with my voice and inflection and everything. They could do it. So probably within a year or two, I'll push a button and it will be me doing this AI seminar. So AI can do, and it can do text. If you can type in stuff and it will turn it into speech. You can type in stuff and it will turn it into video. It can do perfect music. It can replicate. It can create new music. And in time, and not in long time at all, it will be doing full feature-length films from start to finish, including the script, the choreography, the characters. It will have AI actors. And it will be, and I'm sorry to say this to all the creative group out there, it will be as good as people can create, because fundamentally we are neuron connections, and computers have more neuron connections than we do. And so they will beat us, which now, and all of this, this remarkable ability triggers just an avalanche of legal issues, just an absolute, it's a brand new world. And so buckle up. There's going to, and for the best part to be litigators, because there's going to be so much litigation on this forever. And I'll be touching on a lot of the issues. Let's start. I'm going to start today with, and by the one thing I do want to mention is AI submitted material is winning awards when people aren't aware that it is AI submitted material. That is how good it is. It's winning music awards, art awards, and short film awards. And then it's to the chagrin of the awardors that give it, that say, oh my God, it was AI, and they want to revoke it. So that's how good it's gotten. But and short film so far, not yet the long film, but boy, that's coming. So lawsuits, and let's start with copyright, which is probably the biggest. First issue, uploading. The AI is, what it's doing is it's sucking up everything in the world, and anybody who has any ownership of copyright to anything in the world is suing all the AI companies for that uploading itself. And they're claiming that that's copyright infringement, which it is. And the issue all boils down to fair use. Is that uploading, which is copying, and therefore it's on prima facie copyright infringement, is it protected by fair use? And there's now been a slew of cases on this question. And fair use ultimately boils down to, do you think it's fair? And it's really a rule with your heart question. And the two competing arguments that's going on right now is you've got the old Google versus the Association of Library Authors, that where the Second Circuit said Google was allowed to upload all the books because isn't this a wonderful thing? And they're only going to show snippets, and it advances humankind, and it's just a wonderful thing. The counter side is really the Andy Warhol Supreme Court decision, where fundamentally it said that copyright infringement is not fair use if the owner of the copyrighted material would expect to get paid for whatever was done with the work. And if you apply that analysis to what's going on, the answer is pretty obviously the people that create the copyright, who own the copyrighted material, expect to get paid because they're all suing to get paid. So it kind of answers the question. Now, where the cases come out? There's three important cases this year, 2025. You've got the Thomas Reuters versus Ross decision earlier this year that on pretty extreme facts held that uploading was not fair use. It was copyright infringement, and all the copyright owners went, yay, yay, okay, we're going to win. And then, unfortunately, this summer, two horrific cases came out that held that it was fair use. And the first one was the Anthropic case. Second was the Meta case. And both of those cases held that the uploading was fair use. They fundamentally relied on this prior Google versus Library Association case, and they basically said, "Oh, isn't this a wonderful thing? We're advancing humankind, blah blah blah, and therefore it's fair use." To me, the flaw with both of those decisions is they focused on one of the factors in fair use is the impact on the market. And both of those cases looked at the market as being the output side of AI. That is, what does the AI do with this material? Does it spit out books? Does it spit out music? Whatever it does that output compete with the uploaded material? To me, that is the wrong analysis, that the uploading itself is the market. There is absolutely now a very vibrant commercial market for uploading, and that is the impact on the market, of course, is that the AI companies, by scooping up all this stuff, is wiping out the market for uploading. And there's a pending case by the New York Times. They're very aware of this issue. They're 100% focused on it, and I'm rooting for them that they will get the court to recognize that the market is the uploading. It's not the output. So let's all, for those that own copyright, let's root for the New York Times, because they definitely are onto this question. There was a proposed settlement that a court rejected by Anthropic for $1.4 billion that you'll see and people are misinterpreting that as being that Anthropic was liable somehow for this uploading. That was a different issue. That was what Anthropic had done, is they had sucked up all these they had saved to their library books that were stolen and that were online, and that was not that $1.4 billion settlement is for a different aspect of that case. So right now, you have two horrific cases that uploading is fair use. I just want it not to be diverted by that Anthropic settlement, because that's really a different issue. What else on this topic? The Copyright Office issued a report that said that uploading might be infringement. And the day after they issued that report, the head of the Copyright Office was promptly fired. And no doubt that he was fired because Trump, and this may be the most important legal development of all, oddly, is Trump has now announced his position loudly and clearly that uploading should be allowed. And given the Supreme Court's predilection to go along with whatever Trump wants, I would not be surprised that, based on where the trend is going, Meta, Anthropic, Trump's announcement, that when this gets to the Supreme Court, I would not be surprised if the holding is that uploading is fair use. That is going to be my current vote. I was previously going to vote in favor that it would not be fair use based on the Andy Warhol case, because to me the market is the uploading, and that is clearly has an impact on, stealing the books and the films and everything. To me is absolutely destroying the market for the uploading. But so be it. So keep your eyes on what does the Supreme Court do. This will all obviously have to be resolved by the Supreme Court. Next, one thing to think about on this uploading question, which is to me fascinating, but no one's done. If I was an AI company and I was uploading, boy, I would be doing it out in the middle of the Atlantic, or I would be doing it in Zimbabwe or someplace where there's not copyright infringement enforcement, because the copying is a jurisdictional issue and it depends on where the copying occurs. And there was an interesting UK case where they brought a copyright infringement case in the UK, but the the AI company said, I didn't do it in the UK, and the UK had to throw out that aspect of the case because it depends where the copying occurs. So it's interesting that AI companies have not focused on that and been a little smarter on where they do the uploading. Now, it brings us to the output side. Now the AI sucked up everything in the world, and now it starts spitting out stuff, and everybody's suing over that as well. So anybody who got uploaded is now suing on the output side. And this is a different issue. The first step, one of the claims is, hey, you uploaded my stuff, so I must be in that output somewhere. I must be in there somewhere. And therefore that output is copyright infringement. Those claims are all losing, as they should, because all art is based on prior art. And even when anybody is a musician or an artist, they are impacted by what they previously saw, read, heard. And so to some extent, what they previously saw, read, heard is reflected in what they do. So that the I'm in there somewhere claim is losing. The claim that is winning is, wait a minute, that is too similar to my work. And this is a classic copyright claim, and it's a two-step analysis. This first step is it a derivative work? And that is as with fair use, it's a rule with your heart question. You look at the old, you look at the new, and you say to yourself, are they too similar? And if you think they're too similar, then you go, it's a derivative work. It's based upon the original. It's substantially similar. You put a bunch of words on the opinion and you rule that it's a derivative work. If you think they're far enough apart, then you say, it's not derivative. It's not based upon. It's not substantially similar. You put a lot of words in the opinion and you come to the opposite conclusion. Once you have a derivative work, your next question is, okay, who did it? And this is an interesting one because the AI companies are often saying, we didn't do it, our customers did it. All we are is, we're just a service, and our customers came and did all this stuff. And by the way, if you have a lawsuit, go sue the customers. And then, by the way, if they post it back on our service, which is what's happening, then the claim is, that's, that we're protected by the Digital Millennium Copyright Act. Send us a takedown notice and we'll take it down. But we aren't liable. This is the safe harbor under the DMCA, and so you can't go after us. This is where this is coming up in spades is the Disney, Universal, and Warner now suing Midjourney, and Midjourney is precisely what's happening. Customers are Midjourney's uploading everything. Customers are downloading. They're creating all the same images using the uploaded stuff. Then they're posting it on Midjourney, and Midjourney, no doubt, is going to say, "Hey, we didn't do it," and by the way, just send us a takedown notice. So the counter to that, and where I think this is going to go, is it's the argument between Betamax, the old Betamax case, and Grokster and Napster on the other side. And the question will ultimately be, was there intentional promotion of infringement? And my God, if Midjourney did not intentionally promote infringement, nobody did. So I'm betting against Midjourney on this one. They are no question that they are intentionally, with malice aforethought, encouraging people to rip off copyrighted material from all the studios and create their own Star Wars, Batman, whatever, and now post it up on Midjourney. So to me, this is just a slam dunk against Midjourney on a Napster versus and Grokster theory. But interestingly, it's not a copyright. It's not a direct copyright infringement. It's more like a aiding and abetting and encouragement. Step 3 in this analysis. Okay, so now you've got, it is a derivative work, and whoever it is liable for it. And then the question is fair use. And fair use, back again, is rule with your heart. Do you think it's fair? And the one important change in the analysis here is Andy Warhol case. It used to be the case that transformative was a defense under fair use for copyright, and transformative was interpreted as you did something creative with the original work. You morphed it, you changed it, you colorized it, and that was the Andy Warhol case, and the Supreme Court said, nah, that's not what we mean by transformative. So whether you modify it or transform it or do something, that is not transformative. And that's, to me, this is a very important. So AI can't rely on the fact that it changed the original work in some way and say, aha, that's transformative. In most cases, if you get past these two things, you've got a derivative work and you've got the right defendant, I don't think that fair use will apply, because you now clearly have a derivative work that looks like the original or close enough that it's a derivative work, and I think that's going to be liability. But footnote for everybody, I should have said this earlier. I will take questions at the end. I should have said this earlier. My apologies. If you write out the questions, I'm going to take questions at the end till the cows come home. Please make them short. I would like them to be like not more than a sentence or two, 3 lines or less, and so that I can catch up with them. And then we'll do all questions at the end. And my apologies for not saying that earlier. Onward. The Copyright Office, in that report that I mentioned earlier, also said that the output could be infringing and might not be protected by fair use. But once again, the person that wrote that report was fired the next day. But I really think that was the objection was the uploading, not the output. I would be surprised if anybody, if even Trump thought that it was fair to just go and rip off and then do Star Wars imitations and, Batman imitations. I would be very, very surprised if that was what the intent. Next big issue, and this is a very big issue with copyright, is that AI created material itself is not protected by copyright. And this was the issue. The Copyright Office has said it loud and clear. The cases have all supported that. I don't see any change in that. I don't think that's going to change on appeal or anywhere else, but people are still fighting it. But what that means is that if you can't protect it under copyright, that because of copyright preemption, it means that you can't protect it under state law either, and therefore you can't protect it at all. You can't do a takedown notice if it pops up on YouTube, because takedown notice only applies for copyrighted material, and therefore so you have no protection. Footnote is that you may have read Disney just fired an animator that was using AI for their animation, and I'm going to guess that it was for 2 reasons. One of which is that animation that is created by AI cannot be protected by copyright, and so Disney would lose the copyright would just not be able to protect any animation that is created by AI. So that's a very obvious reason for not using AI to create particularly animation. So now what do you do if you can't, if you can't protect it? People are pushing the boundaries of this in all different ways. Some people are saying, I told the computer what to do. My prompt was so creative that you've got to protect my prompt, and therefore whatever the computer did was a derivative work of my brilliant prompt. Some people are saying, look, it's like Photoshop, and I modified the output, or I told it to do some changes, and you're really, there'll be a lot of litigation on the boundaries between if you did something after, if you did something before, what's it take? But clearly, my analysis is whatever the human did is protected, but whatever additional elements that the AI created is just not protected. And so you can parse it out. If the humans did some part of it, you're going to have to parse it out. And in fact, when you go to the Copyright Office, you are supposed to identify the parts that are created by AI and the parts that were created by a human, which brings me to the great defense that I am sure that most of the people are going to use, which is the great, I forgot defense. And I guarantee you, I promise you that everybody is going to go register their work in the Copyright Office, and they are going to forget that it was created by AI. And they're just going to register it as the author and gun it. And good luck for other people trying to figure out if it was or was not created by AI, because it's not easy to tell, and it's getting harder and harder to tell. And so that is obviously what people are going to do, is just as a practical matter. What are the legal solutions, putting aside the I forgot defense? What are what solutions can you adopt if you're a studio, if you're whatever you're doing that's using AI to protect the work? I give two suggestions to my clients. Suggestion one is, have a human with flesh and blood write the original treatment and go record that in the Copyright Office, and that becomes the basis for your copyright claim. And then you can have the script written by AI and the film written by AI, and the everything that follows from that, as long as it's based upon that original treatment, will be a derivative work of the treatment that can be separately protected, at least as to the fundamental story. You won't be able to protect the AI created visual elements or additional elements, but nobody will be able to take that film that results and go and just copy it and run with it, because it will be a derivative work based on the treatment, and you'll be able to sue on that. So that's plan one for how to solve the problem. Plan two is, you let the AI do everything, just have at it, and at the end, have some human go through and do stuff to the final visuals, colorization, add a few special effects. Personally, have somebody do it, and then bury enough in it that there are copyright elements that if somebody goes and tries to rip it off, you'll be able to point to, like fingerprints on like what they do with Google on a map. There'll be some fingerprints that you can point to and say, aha, those are human created copyright elements, and you stole it. So that's what those are the two suggestions that I've got beyond the I forgot defense. Let's look at the Disney, Universal, and Warner versus Midjourney. All right, let's put all this in context now. So where did Midjourney do the copying? Interestingly, I haven't seen anything that said it, but if they were smart, they would have done it outside the US. And the first defense they would have said is no jurisdiction in the US because I copied it outside the US. I don't know if they've even filed an answer yet, but that would be a fun answer. The second answer is coming is, hey, this is fair use. Go read Anthropic and Meta, and all we did is upload all this stuff. And so the uploading, you can't tag us. And that's bad. That may be under current law based on Anthropic and Meta, the uploading itself may not be alone. How about the downloading? Well, they clearly were derivative works. You've got Star Wars, you've got Batman, you've got everybody. It's, they're identical. There's no question that it's a derivative work, but Meta's defense, Midjourney's defense is going to be, we didn't do it. Our customers did it. And, oh, they posted it on our website. Oh, too bad. DMCA, send us a takedown notice and we'll take it down. That'll obviously be their defense. And the studio's not going to sue the customers for infringement. And so that's what Midjourney is obviously hoping is they won't sue the customers. They can't sue us because of all they can do is send a takedown notice. And where I think they get nailed again is the Grokster versus Napster. I read the Disney and Universal complaint, and they clearly are all over it, which is this was intentional encouragement for infringement. If there's ever a case for aiding and abetting and beyond aiding and abetting, I mean, this is it. So I'm going to hope that is the ultimate outcome on that. Warning to people that use AI services. You've got to read the terms of use, because on some of them, including Midjourney, if you upload stuff that you own, the terms of use say that that it effectively becomes public domain. It effectively says that that Midjourney owns it. Whatever you upload, like if you say, oh, here's like if Disney, I can, intentionally uploaded Mickey Mouse. They'll never do this, but and to Midjourney and said, please make the ears yellow. Boom, under the Midjourney terms of use, Midjourney now owns Mickey Mouse, and they can give it to any of their customers and let anybody use it. So you've got to be, and this may be another reason that Disney fired that animator. God knows what the animator uploaded or what I don't know what AI service they used, but heaven forbid they used Midjourney and a lot of the AI services, some of them have very good terms of use, some of them don't. You got to read the terms of use before you upload anything to AI. Warning, warning. Done with copyright. Let's move on to trademark. Okay, just as a general, first I want to just give a general background of trademark before we do the AI implications. Trademark is aimed, it's different than copyright. It is aimed at consumer confusion as to the source of the goods. As long as there's no consumer confusion as to the source of the goods, you can use trademark. So if you're watching a film and you see a car, a Mercedes drive by with the Mercedes emblem, or you see McDonald's golden arches, that is not trademark infringement, because a reasonable consumer would not think that McDonald's or Mercedes produced that film. And so there's people sue over this all the time and they lose all the time. Pepperdine just sued over this, sued Netflix over the Waves trademark, but it was clearly not being used to identify the source of the goods. So you get this all the time. Now, which brings us to AI. My favorite one on this is that Stable Diffusion uploaded all the Getty images, claiming that it was fair use, of course, and then spit out photos that did not look like the Getty photos, but with humor from the legal side, the photo said Getty images on the output, and so a reasonable person looking at that photo saying Getty images, even though it wasn't an original Getty image, would think Getty images created that, and that was and Getty immediately sued for trademark infringement, and they're right. So they didn't have to sue for copyright. They didn't forget the uploading, forget the output. This is just a trademark claim. What are you doing using our trademark to identify your goods? You can imagine that if I did a film and I said, please put presented by Disney, or if the AI just happened to spit out, it thought it was a wonderful idea. Boy, the film would be much better received if it says presented by Disney. You can imagine Disney being a bit annoyed on the trademark side, and with good cause. So AI can cause trademark infringement, and it'll be, and you can, or you can imagine I tell it. Can also, you can imagine I say, please make a film called Galaxy Wars, and Galaxy Wars, and the question is that a trademark infringement for Star Wars? And again, the litigators can have fun arguing it. Where this is going to get really fun is AI created actors, and AI created actors are already there in the social media space. There are influencers that are completely created by AI, and they are having a wonderful time living the life of the rich and famous. They've got cars and pools and everybody, and they actually have hundreds of thousands of followers. And the people that are creating those AI created influencers are making a bucket of money every month using that image. Now, given that it's created by AI, you can't protect it by copyright. So how do you protect and this is what's going to happen with the studios, I guarantee it, is they're going to have AI created actors that will star in film after film, and they might even have their own off-screen quote persona, because people buy it. Like, go figure, people actually like public buys it. And so how will the studios and how do the influencers protect the trademark, these characters. And the only way you can protect it is with trademark. And so what I have suggested is you use an AI character that doesn't look like anybody obvious. You make the image very distinctive. You identify the image with the source of a particular good. So, for example, you put the actor's name in the front of where the film is presented by, and you have the actor's name and their image, and you use it in multiple films, and you file a trademark registration using it, and you put it in ads, and you protect it with trademark. And that's what I think is going to happen, because you won't be able to protect it with copyright. So I think that's the way that people are going to be able to do it. Next, big fight, right of publicity. All right, so this is where AI gets really fun. Pardon me. Okay, summary of right of publicity before we get into the AI elements is that you have a prima facie claim anytime anybody uses somebody's voice, name, or image for any purpose. That's a kind of a prima facie case. And then you have a bunch of defenses that apply. And the problem right now is that it is a state by state question of the defenses. There's no federal right of publicity, and the states are all over the board. Some states base jurisdiction and choice of law based on where the exploitation occurred. Some states look to the residence of the plaintiff. And so point of exploitation versus residence is a big split. And then some states have different defenses. Some states say all expressive works are protected. Some states say only transformative works are protected. And when they use the word transformative, they are using the old pre-Andy Warhol copyright description of transformative. You've modified it in some way, like this is the California case of the Winter Brothers that were turned into half worms and was held to be protected because they were transformed, even though it was obviously the Winter Brothers. And my hope is that the Andy Warhol decision bleeds into the right of publicity and stops that kind of analysis. But that is, some states apply that. Some states say, well, if the work is protected by copyright, then copyright preempts a right of publicity claim. I think that is nuts, but a lot of cases are doing that. And then some states, like California, allow the protection to apply to the estates of celebrities so that estates can enforce it. Importantly, California, as of 2025, passed legislation that closed up a loophole that permits the use of deceased celebrities for an entertainment or dramatic work. And that got closed off from, at least as to digital replicas, is no longer allowed starting in 2025. So you can't use the deceased celebrity as a digital replica in an entertainment or dramatic work. Also starting in 2025, California purported to not permit people to waive their right of publicity in a contract to permit third parties to create digital replicas of the person. So an actor can't, under California law, can't sign a contract that says, go have at it and use my image to making digital replicas. Those contracts, in theory, are no longer valid as a violation of public policy. However, they are riddled with exceptions, that they are this supposed prohibition is so easy to get around. So if you run into this, it doesn't apply to SAG actors because they're separately protected, which we'll talk about later. It doesn't apply if the person was represented by a lawyer. It doesn't apply if the use of the image is done to do something that the individual would not otherwise do, which is pretty simple to meet. Or if they give a reasonably specific description of what it is they're going to do. I'm going to make turn you into a dinosaur or whatever they're going to do. All you have to do is say it. So this alleged prohibition is kind of riddled with exceptions. Now, what do you do with a service, with an AI service that allows consumers to upload an image of a person and convert that person into another picture, a film, a something that, and this is what AI companies easily let people do. And the AI companies are saying, hey, I didn't do it. I just work here. Somebody else, they uploaded a picture, and often there's a terms of use that says you have to supposedly check a box that says that you have authority to use this person's picture, which everybody checks the box, but nobody has authority. So what do you do in this situation? Or the voice. This is also coming up. We have clients whose voices are being used by a text to speech companies, and they are, and where their customers are clearly infringing the voice of our celebrity clients. So what do you do? I think this is a Betamax versus Grokster and Napster case. I think, again, that if the service is intentionally encouraging the use of kind of infringement of people's right of publicity, that just like you could bring a copyright claim, you should be able to bring a right of publicity claim. You're aiding and abetting the tort of violation of the person's right of publicity, and you can sue them. This is going to be a hot issue going forward, and we have clients where this is a significant issue. What do you do if the service allows you to put the resulting picture up on their site, and there's a picture of your celebrity up on the site of Midjourney or whatever it is, and you can't do a takedown because the takedown procedures and that safe harbor only applies to copyright. It doesn't apply to right of publicity. And there's a circuit split as to whether the services are protected by Section 230 of the Communications Decency Act. And the Ninth Circuit says that they are protected by Section 230, and the Third Circuit says that they're not. So right now you have a split. If a service is violating somebody's right of publicity, whether or not you can sue them, or whether they have this Section 230 protection. More fun on right of publicity. In June, New York passed legislation that required any advertisement that uses a digital image, what they call a synthetic performer, someone created by AI, has to disclose that fact on the advertisement. It has to say this ad includes somebody that is a synthetic performer. And unless it's an ad for a film that person appears in, basically. So that synthetic performer performs in. Federal legislation. There is a crying need for federal legislation on this issue. It is an absolute, you've got copyright, trademark, patent. Right of publicity is an enormously valuable intellectual property right. Why isn't there a federal legislation? Well, there kind of is, and there kind of isn't. They actually managed to pass an act earlier this year called the Take It Down Act, which would have been the perfect vehicle to really lock up a federal legislation on right publicity. Unfortunately, it was limited to nude pictures. So either it was aimed at the Taylor Swift situation. So either you've digitally created somebody to look like they're a nude, or it's revenge pornography, one of the two. But unfortunately, it was limited just to nudes. And there was a second act that is pending that is called the No Fakes Act, that is a broad right of publicity statute. It's being pushed by the guilds, it's pushed by celebrities, and unfortunately, it is going nowhere fast. So that act has been pending for a couple of years, and I don't see it passing. Unfortunately, I think they did the Take It Down Act and then patted themselves on the back and then moved on. Um, next, defamation. I love this. I predicted the outcome of this, and the outcome happened. So here's summary of defamation. General rule is you're not allowed to say false defamatory facts about somebody that gives rise to potential liability. If they are a public figure or it is a matter of public interest, then there's this actual malice standard, which has nothing to do with malice and has nothing to, it's a rather ridiculous term. The standard is whether the person saying it had an honest belief as to the truth of the whatever they said. As long as the person saying, if you're dealing with a public figure or you're dealing with a matter of public interest, as long as the person saying the defamatory thing believed it, honestly believed it, that is a defense. And so I'm going to quote the Supreme Court on this one. There also has to be is that the defendant actually, the only way you can find liability is if the defendant, quote, actually had a high degree of awareness of probable falsity. So earlier this year, ChatGPT was sued, or OpenAI was sued by something ChatGPT said, which was defamatory of a public figure. And the court said two critically important things. One is it said a computer can't have actual malice because a computer doesn't have any intention. And therefore, under that standard, you cannot, an AI company cannot defame a public celebrity or a matter of public interest because, or it won't be held liable for it because it has no intention at all. It's just rambling, hallucination. The second thing it said, which was even worse, is that reasonable people should know that ChatGPT hallucinates. And therefore, you can't trust anything it says. And therefore, it's not defamatory because no reasonable person should believe it. Now, that means that you can't, what that does is a per se defense for all AI companies for defamation, whether it's a public figure or not. Public figures can't sue because because a AI service doesn't have intent, and non-public figures can't sue because everyone should know that whatever it says nasty, no one should believe. Now, what's ridiculous about that is people absolutely believe what ChatGPT says, and if there was ever any better proof of it, it is that every single day, lawyers are including what ChatGPT says in their briefs, most of which is wrong, and and they're getting sanctioned for it, which I'll talk about later. But people clearly believe what AI companies say. They ask it all. I get clients sending me stuff all the time. Hey, ChatGPT said this, and ChatGPT said that. Like, are you kidding me? But they believe it. So defamation, can't sue them. Next, another claim, false advertising or unfair business practice. So where this is coming up is we had an associate in our firm that actually brought this all the way up to the California Supreme Court. They sued Sony for releasing a record that was supposedly sung by Michael Jackson, and they released it after his death. They said it was Michael Jackson pre-death recorded tracks. Was not true. They had created it using AI and digital. They'd actually created it using digital techniques equivalent of AI. That was held to be an unfair business practice, and so that is with us. You can always think of a claim when you see an AI created something, and we'll talk about some examples. What was it? Was there misrepresentation as to the source and the original of what this is? Because if they're passing it off as being true and real, and it's not, it was created by AI, then there's potential liability. Okay, let's now, you're a studio and somebody has given you a script, a movie, a something, and they say, this, and it's wonderful, please buy it. What do you do? How do you know that it wasn't created by AI? And what are your remedies? So the practical attempted solution is that there is now AI detecting software that you can run the whatever through, the film, the script, the whatever, that supposedly will tell you if it's created by AI, but it's an arms race. And I will tell you that AI is winning this race, and that the detection software is losing, because AI is getting better and better, and it's getting harder and harder to detect. Second thing you can do if you're a studio is obviously get reps and warranties, and you really care about this because the AI elements are not protected. So if that film was created by AI, and anybody can take it, you're in trouble. Like you're in deep trouble. Now, this is no doubt why Disney fired the animator that was using AI, because that whatever is created wouldn't be protected. And this is and even the protected elements, like even if that person ran those protected elements through an AI service that had bad terms of service, like Midjourney, then even the protected elements may now become effectively public domain. So how do you protect? I mean, and the answer is, I don't know how you protect yourself. I think AI detecting software doesn't really work. What, indemnity from a penniless producer? You better have a deep pocket that you can sue, because the studios really are at risk unless they create it from scratch and know every step of the way, and nobody was dumb enough to run it through an AI machine. Okay. If you do have a claim, you have whether right, a publicity, defamation, unfair prison, who do you sue? Who do you sue? Do you sue the consumer, which is in most cases who's doing it? Do you sue the owner of the content? In many cases, like you can imagine a studio picking up something that was created that they didn't know that was a violation of something. Or do you sue the service that created it, the open AIs of the world, the stable diffusions? And so there's a lot of litigation on who is liable for whatever the claim is. And then you're going to have all the, the defenses, whether it's the safe harbor takedown notice, or is it the Section 230? So for the litigators out there, you're going to have a party. Absolutely a party. Guild issues. Buckle up, boys, because next year it's going to be chaos as the guild agreements all come due, because they expire next year, and it's going to get wild. And it's already got wild in the last one. If you think it was wild the last one, it's going to get wilder. Here's where it stands right now. The DGA kicked the can down the road for 3 years, and they got their agreement says that the studios cannot use AI to replace someone that was a DGA member. So it effectively stops studios that are signatures to the DGA from using AI to create a film, because of course that would replace a DGA member. But they have affiliates, and they do negative pickups, and they do all kind of things where they can side run that. The WGA got a provision that said AI created material is not does not count as literary material for purposes of compensation and credit. That was widely misinterpreted as that studios couldn't use AI to create literary material. That is not correct. Studios can create, can use AI, but whoever touches it, any WGA member that touches it becomes the deemed author of it for compensation and credit. So if they have AI create a screenplay, and they ask a writer to do a few polish, to do a quick polish, that WGA member will become the author of the screenplay for purposes of compensation and credit. The real question will be, what happens if the studios just bypass writers completely and have AI create it from ground zero? They obviously won't do that because the screenplay won't be protected by copyright. But what they might do is have a non-WGA writer write a treatment, do a negative, pick it up from somebody that's not WGA, and or have an affiliate that's not WGA, and then have AI go take it from there. And that's, I think, going to be part of the discussion next year as to what the WGA does about that. SAG got protection for their members that basically requires very extensive contract provisions, has to be clear and conspicuous, has to be signed in a separate writing, has to have a very clear description of what's used, of what the intended use was. And if they use the actor's physical participation at all, they have to pay them residuals. So actors are, like, why not? If I was an actor, I'd say, fine, use my image, but as long as you pay me. The real question will be synthetic performers. And one of the questions will be whether SAG has any jurisdiction over the use of completely made up performers by AI. And will SAG have any jurisdiction on that at all? And in the agreement, it says that if the studios create a synthetic performer, they have to give notice to SAG and an opportunity to bargain in good faith over, quote, appropriate consideration, if any. Now, I guarantee you the studios are going to say the appropriate consideration is zero because SAG has no jurisdiction over special effects, which they will treat this as. And so that will be a fun issue if litigated, and it will be a more fun issue when this comes up next year because it's getting closer and closer to the studios doing exactly this. As just a kind of a warning shot across the bow, SAG brought charges against Fortnite earlier this year for using Darth Vader's voice with permission of the estate. Darth Vader's, the person that did his voice, they got the permission of the estate, but SAG said you failed to bargain in good faith to use guild members to do this. And so, and shortly after that, they settled and entered into a new agreement for video games. But you can, SAG has laid down at least where it plans to go with this. If people are going to use synthetic performers, they're going to say that's a failure to bargain in good faith and it's an unfair labor practice. Let's look at a lot of this now in the one of the early ones that came out on this was Heart on My Sleeve by Drake and Weeknd. And it came out a couple of years ago. It was what really started the flurry of attention to this. And just for the fun of it, let's go down the analysis. Let's look at copyright. Let's look at, all the issues we've discussed, trademark, right of publicity. So copyright. The song itself had no copyright protection because it was created by AI. So anybody could copy it and use it. There would have been no takedown right of Universal to take it down, other than the happy fact for Universal that there was a short clip of a Universal song that they could use to flag and take it down under as a copyright. There would just happen to be one clip. But for that clip, they would not have been able to do that. How about copyright infringement based on existing songs? Was it too close to an existing song? And I don't think it was. I think that, yes, the genre and the general feeling was, yeah, you understood that it was Drake and Weeknd, but it wasn't so similar to an existing song that you would say, hey, that was a derivative work of an existing song and therefore copyright infringement. How about trademark? You clearly saw the name of Drake and Weeknd but there was a disclaimer that said it was created by AI, and therefore that would have defeated a reasonable consumer's belief as to the source of the goods. And so I don't think that there was trademark infringement because of that disclaimer. Similarly, I don't think that there was false advertising or an unfair business practice because, again, they said it was created by AI, and that should have been sufficient a disclaimer to avoid a claim on that basis. What about Drake and Weekend saying, hey, you're violating my right of publicity? And I frankly think, yeah, I think it was. It had their names. It was clearly their style. And now you get to the state law problem. Where do you sue? Are you suing at point of exploitation, or are you suing based on residence? And now let's look at the defenses. Some courts say, hey, that's an expressive work, and therefore it's protect, you can't sue. No, you can't bring a right of publicity claim against an expressive work. God bless the First Amendment for some reason. Or some cases would say, hey, that's transformative. That wasn't in the very fact that it wasn't actually Drake and Weekend was there. Therefore, it was a mutation of them, and therefore it's transformative. Note again, this is no longer a defense for copyright, because under Andy Warhol, that is no longer a valid defense in copyright. But for right of publicity, it still exists. How about you suing YouTube? Can they sue YouTube for violating their right of publicity? And this goes to what circuit you sue in. Because does YouTube have Section 230 protection of the Communication Decency Act? And the Ninth Circuit would say yes, that is protected. And in the Third Circuit, they would say, yeah, you can sue. So it really is a function of where you sue. And last but not least on AI, and as a warning to all my lawyer friends out there, 3 years ago, there was a case that a lawyer got nailed for using AI in a brief. And I thought, oh boy, that was ridiculous. I mean, it did a fake citations, and the guy didn't check. And I thought, well, that'll never happen again. Everyone's obviously read that article. And then it started happening every month. And then it started happening every week. And now it happens every day. And in fact, a judge got popped for it. So it is so unbelievable that people are using this and relying on it, which shows that they believe it, by the way, if you get back to the defamation thing. And it's just phenomenal that people are relying so heavily on this, and it literally is every day. So please don't rely on AI. Check what it says. I look at it all the time. I use it for research and stuff, but you have to check every single time, because half the time it's wrong. It gets you close. Sometimes it gives you a good citation that you can go read, but you just can't rely on it. And now the promotional part of the program. If you want to be added to my newsletter, I send out a newsletter every month. Just pop me an email with the word "add" at the top. My email is smore, MOORE, at ggfirm.com. That's really easy. smore at ggfirm.com. And I will add you to my newsletter list. I send out every month. And if I have a whole entire course on YouTube that I used to teach I taught at UCLA Law School for many years, and I taught at USC. I taught at the business school at UCLA, and I recorded the course basically and put it on YouTube. So if you search Sky Moore Attorney altogether, Sky Moore Attorney, you will find my course on YouTube. And I have a bunch of articles on Forbes that you can read anytime. And I have a book that is called The Biz. And I think I've lost you. Am I still there? Sorry, I think
you're still here.
Okay, and so what I want to do is hold on one second. I want to pull up with luck a copy of The Biz. And if you don't have, is that on my screen?
Yes.
And if you don't have it, you should get this. It's a great overview of the industry. It's in its 6th edition. It's a very popular book. A lot of people have it, and I strongly recommend it. It's on Amazon, and it's just a good and everything we've talked about today is in there, plus a lot more. And with that, I am standing by to take any questions if you would be so kind as to read them. And I would be glad to stay as long as people want. And I can bore people to death answering questions.
Great. What is your interpretation of transformative post-Warhol?
My interpretation in copyright is that it is transformative, means you have to be using it for a very different purpose. It's not just changing it in some little way. You have to be using something from, like, for education or for news. That is, quote, transformative. It's the different use, not different modification.
Oh, great. Let's see. Has the 2025 California laws re digital replicas been challenged on a First Amendment basis?
No, no, not yet. Not yet.
All right. And what if an artist's will/trust allows the estate or heirs to create post-mortem digital replicas and license them to make movies?
Say that again. Sorry, say it again.
So, what if an artist's will/trust allows the estate to create post-mortem digital replicas and license
Right?
them to make
Yeah,
movies?
that should be allowed. That should be enforceable. Yeah.
All right, let's see. What else do we have here? And as you stated, all human art is derivative in some form of prior work. So, how is Midjourney's inspiration illegally derivative?
Because it is an identical copy of it's Star Wars, it's the Star Troopers, it's Batman. This is not some different version. They are doing absolute identical replicas of original copyrighted works. That it is not even close to being, something else.
All right, let's see. So, regarding the need for federal legislation to unify on rate of publicity, do you think there's a greater chance that federal law would remove all restrictions on AI?
No, no way. Will remove all restrictions on AI. Well, I hear the question because that was proposed in the recent big beautiful bill that got dropped out. I don't think that'll happen. There was too much flack against it. So no, short answer is I don't think that will happen.
All right, let's see what we have here. Let's see. Can you give more examples regarding trademarks in AI?
And it'll all come down, trademarking and AI, it'll all come down to consumer confusion as to the source of the good. So it is, again, I love the Getty images showing up in the Stable Diffusion photographs. Again, if I did a film that said presented by Disney, it'll all come down to that. So AI is not capable of avoiding the problem, that's for sure. And so they may walk into it, headlong.
Right. Is the Andy Warhol SCOTUS ruling really broader than that particular type of infringement, or more towards really visual works with near identical new works?
I think Andy Warhol completely changed the analysis of fair use. I think it changed it to the question of, does the owner of the original copyrighted work expect to get paid for whatever was done with their work? I believe that is the new test. And that is why I think that this uploading should be infringement, because the market is the uploading, and to do it for free is clearly just trampling on the expectation of payment of the copyright owners, as you can see, because they're all suing. So I'm shocked at the Meta and Anthropic decision. I'm shocked at it.
All right. So, is the grounds of protection for AB 1836 that the decedent be domiciled in California at the time of death, be a
Yes.
resident of California, or that no company can engage in the use of digital replicas?
Domicile. California is based on domicile at the time of death.
All right. Let's see what else we have.
Yeah, they're a residence test. And California applies a residence, including domicile at time of death.
Okay, and another question, just to be clear, as of 2025 in California, an expressive film utilizing replicas of James Dean or Marilyn Monroe is prohibited without a license from the estate.
If it's a digital, If it's a digital replica, it is prohibited without, unless the time, I forget how long the period is, but unless that time is expired, it is prohibited if it's a digital replica. By the way, they could use an actress that looks like Marilyn Monroe, though, and still get away with it without using a digital replica.
All right. I believe that about wraps up Q&A.
Okay, and so we're done, and I'm deeply honored to have everybody who attended today, and thank you very much, and you'll get CLE credit for this. Thank you.